Hello, everyone. Welcome. Thank you for joining our webinar, Changing Trends in Commercial Arbitration in India, presented in partnership between the Legal 500 and Trilegal. This is our second episode in collaboration with Trilegal. And we held the first one in June when we discussed resuming work in post-pandemic India. I do encourage you to watch this episode, which is available on our YouTube channel. My name is Alan Cohen. I am a research editor at the Legal 500. And before I hand over the webinar to the impressive panel, I'll give a brief introduction of today's topic. As the title suggests, we will discuss how the latest development in commercial arbitration proceedings involving multinational companies have played out in India, including the fact that the Indian government has stated it was aiming at making the country a seat for international arbitration. So anticipated changes raise questions, obviously, such as, do organizations have a choice of law and seat for arbitration while operating in India? Can foreign arbitral awards be enforced in India? And here's just some of the discussion points for today, as we will also discuss emergency arbitration in India, seated arbitrations and bilateral investment treaty disputes. But first, let me introduce Tini Abraham, who will lead us through the discussion, and the panelists who will be with us. Tini Abraham is a partner in Trilegal's Delhi office. She specializes in commercial disputes and regularly represents Indian and multinational clients in complex disputes in institutional and ad hoc arbitrations and before various courts and tribunals in India. Her expertise is sought after in areas ranging from infrastructure contracts, investment by foreign firms in India, and regulatory issues to financial mismanagement, shareholder disputes, and insolvency proceedings. Additionally, she has advised clients on disputes pertaining to media rights licensing, supply contracts, infrastructure contracts, and equity and debt investment contracts. Also joining us is Yogesh Gupta. Mr. Gupta is Larsen & Toubro's Railway Business Verticals Head of Legal. He has 25 years experience across several practice areas and advises on all legal aspects, contracts and disputes of all of L&T railway and metro rail projects in India and abroad. Prior to joining L&T, Mr. Gupta worked as a partner at a top-tier law firm and was an associate with a chamber of renowned senior counsels in India, mostly in practice areas related to banking, telecom and broadcasting, and core infrastructure, advising both private developers and government authorities. Mr. Gupta also has experience advising banks and financial institutions on project financing and recovery matters in high-value transactions. Our third panelist today will be Vivek Gambhir. Mr. Gambhir is a solicitor of England and Wales. He practiced for around 10 years in India and had varied practice, including domestic and international arbitration and advising on multiple power projects. In 1998, he joined a leading international law firm in Hong Kong and later moved to London, where he led the firm's international power practice, working in over 19 jurisdictions on multiple high-value transactions and projects. Then in 2011, he joined the Abu Dhabi National Energy Company of TAQA, a vertically integrated global power, water utility, and oil and gas company, which is listed on the Abu Dhabi Stock Exchange and operates in 11 countries, including India, where Mr. Gambhir is currently general counsel. At TAQA, he's been handling international arbitrations for the company, providing legal and business perspective. I'll hand over to you in a moment, Tini, but before that, I would like to let our audience know that this session is interactive. So if you have any questions during the webinar, please submit them using the Q&A function at the bottom of your screen, and we will put them to the panel once the presentation is over. Okay, Tini, I'm handing this over to you now. Please feel free to introduce the topic a bit further and just lead the conversation, please.
Thank you for the words of introduction, and good evening, good afternoon, good morning, depending where you're joining in from for the session. As you would all agree, the arbitration scene in India has seen rapid changes over the past decade. In fact, during the early years of the millennium, India was considered as a not so friendly jurisdiction as far as arbitration is concerned. And as you would agree, in the last 10 odd years, there has been tremendous changes in the arbitration practice in India, and changes in the legal regime has significantly contributed to the changes in the arbitration practice in making India an arbitration-friendly jurisdiction. Now, some of the trends that have emerged over the past decade, which has significantly contributed to the development of arbitration as the most preferred mode of dispute resolution, is what we aim to discuss during this session today. Now, before we get into a more detailed discussion on some of these issues, I thought we'll just set the context and identify some of the key developments over the last few years, and also what is the emerging trends and what needs to further develop in these key issues. Now, for the purposes of this session, what we were in fact thinking about was to classify these trends under three broad buckets, and the three broad buckets in which these key developments fall are: one is party autonomy. In fact, you would all agree that there has been a fair amount of changes. A lot of issues have gotten settled, and some other issues are still before consideration before courts or legislative changes. And party autonomy, I would say the 3-4 elements which are so central to the point of party autonomy include the ability of the parties to agree on the process of appointment of arbitrators, the ability of the parties to agree on the seat and the governing law for the arbitration, the ability of the parties to choose the institutional routes that would be applicable, the courts that they will go to for interim reliefs, etc. So there has been a fair amount of clarity that has come up with respect to the extent of party autonomy when it comes to choosing arbitration as a mode of dispute resolution and going forward with arbitration as a mode of dispute resolution. The second key area where we have seen trends developing and a lot has evolved is also on the aspect of judicial interference with respect to the conduct of arbitrations. Maybe about 20 odd years ago, India was considered as a jurisdiction where, a foreign award can come to India for enforcement, and you would have instances where the Indian courts have sat in deciding on whether the award should be set aside or not. From that, we have obviously moved to a place where there is minimal judicial interference with the arbitration process, whether it is pre-arbitration, during the arbitration, or post-arbitration. In fact, I must say that in the last few years, we've tried to even give a definition to what you call as the unruly hose of public policy. Now, the third bucket, which has also contributed to the evolution of arbitration, is the maturity and sophistication with which the parties are looking at conducting the arbitration, the kind of importance that parties ascribe to this mode of dispute resolution. That obviously has helped foster the use of arbitration in India. Now, while these are the three broad areas or broad buckets which have contributed significantly in the evolution of this mode of dispute resolution in the last few years, there are certain specific areas or aspects under these buckets which have gained more prominence or received a lot more clarity over the years. And some, as I mentioned earlier, may require a lot more clarity to come through. And these are the few aspects that we would like to segue into during the course of this discussion. But I think before we move into those specific aspects, I would request Vivek and Yogesh to also step in with any preliminary thoughts you have on the emergence of arbitration over the last few years in the Indian context. Vivek, if you would like to add something, please go ahead.
Thank you, Tina. Thank you, everyone, for attending, and good afternoon and good evening to all of you. It's a pleasure to be here. I think there is clearly a momentum that at least I see in India in bringing arbitration as the mainstream dispute resolution um, option available to the parties. And this is not just, it's a conscious effort that is being made, in my view, by the courts and by a number of institutions which are trying to establish arbitration as a mainstay dispute resolution option. And one can see that in the various pronouncements that are coming out from the courts in India, and the changes that are taking place in the institutions that are offering arbitrations, and the number of parties that are going to arbitration. So clearly, all steps are in the right direction towards establishing India as a hub for arbitration. And I think that's probably a goal which is within reach, though there are still some steps to be taken, but it's in the right direction.
Thanks, Vivek. Yogesh, subject to any initial thoughts from you, we can proceed further.
Yes, definitely. Good afternoon and good evening to everyone joined in for this session today. It's my pleasure to be part of this panel on this very, very relevant subject in today's time, which is the emerging trends in arbitration in India. So what Tine and Vivek has already laid a foundation for this discussion today, I would further add to that, yes, India is growing as a go-to arbitration jurisdiction, especially after the 2015 amendment came into the force, and thereafter there are few more amendments which came in 2019, and the work is still in progress to make it more relevant, more efficacious, and more user-friendly. And today in the commercial world, not only in the commercial world, but what I've seen even in the domestic inter-party disputes and the family matters as well, the arbitration is something which is a most sought after mode of dispute resolution, which is being considered by the parties. Even in the family settlement, there is an arbitration clause, and there have been cases where some very, very relevant and good judgments and decisions are coming from the court. So yes, I would say that considering the pendency of the litigation which is there in the courts in the civil jurisdiction, arbitration is a step in the right direction, and industry and people are embracing it with open arms, and this would pave a way for India to become a very, very fair and arbitration friendly jurisdiction going forward.
Thanks, Yogesh, for adding in your thoughts there. Just going back to the fundamental point that I was making earlier, which was that party autonomy is being recognized, by courts, by the legislature, and parties are actually exercising the autonomy that has been given to them, or which has been recognized in the course of the years. Now, one of the key elements of party autonomy is the ability to choose a seat of arbitration. And when you look at the seat of arbitration, there are a few aspects there. One is that we always knew when there is a dispute involving an Indian party and a foreign party, which becomes an international commercial arbitration, parties always had the freedom to seat their arbitration in India, in the jurisdiction of the counterparty, in a neutral third jurisdiction, wherever the parties found it the best for them to seat their arbitration. However, there was this whole debate, which was there for a large number, for several years, in fact, which is that, is this autonomy of freedom is something that is available to domestic parties? Can two Indian parties choose to seat their arbitration in Singapore? Can they choose to seat their arbitration in London? Or they have to seat their arbitration where the parties have entered into a contract, or where the parties have a registered office or any nexus to the contract itself. So that has been a big debate which has been going on for a long while. And taking that debate forward, now we have some clarity as far as the ability of Indian parties to have a seat both in the context of within India and outside India, which is that you're not limited by the place of the contract or the place of the registered office of the parties or the place where the contract is being performed, but you can in fact give a seat to some other place as well. So that's one big development which has come over the last few years. Similar to that is another big development, which was that you can in fact have your arbitration outside of India if that is what the parties want to do. Now, both these aspects have significantly contributed to bringing in that autonomy to how the parties would like to run their arbitration. In this context, I just wanted to check with Vivek on how you look at this development, One, whether it is a positive development, whether this will remain as a development which will be used by a limited number of parties, or you would see a large number of takers who would actually use this autonomy which has been clarified and given to the parties now.
Thank you, Tini. Naturally, I think this question has to be examined in the context of, from my point of view, the fact that those who are investing in India or doing business in India from outside need to do it through an Indian vehicle. And typically, in one of the arbitrations in one of the contracts that I had to deal with, this was a question which had popped up. Can we agree to having an arbitration outside India because we are investing through an Indian vehicle and the other side is an Indian party, and then therefore this may be something that is not available? Well, we chose to still exercise the right to have the arbitration outside India. But despite there being some ambiguity in the law, I think that ambiguity has now been cleared. From what I read in the judgments, it seems that the legislature had already provided for it. It was just a case of getting that intention clearly set out in a judgment, which would, or in court pronouncements, which would clarify that position. So I personally think it's a very good development. It's a choice that is given. But I would also like to emphasize that it is not something which one would just exercise for the sake of exercising, because it's not about holding arbitrations outside, because you could choose to have the seat in India, but have the venue as outside if that's what you want. I think there are some considerations that need to go into deciding whether the seat should be outside India or not. And based on those considerations, I would like to think that two Indian parties wanting to do business, or who are doing business in India in the ordinary course, don't necessarily have a foreign element. There seems to be very little value addition to going outside India, because you could adopt the rules of an international arbitration and conduct the arbitration in India and have the arbitration administered. Because the Indian parties are sort of, they know how to navigate their way through the judicial process and are familiar and accustomed to the laws. It would be Indian law which would be applicable. But when it comes to international parties who are investing in the counterparties in Indian party, there is some consideration that is given to the fact that you probably want a slightly neutral place to have a dispute resolved. you're not that familiar and comfortable with the Indian system. And some seem to think that perhaps that would also reduce the possibility of frivolous arbitrations being brought. But more importantly, I think the consideration of seat has to be very carefully taken, because it has consequences attached to it. You will not only be having possibly the venue, but you are choosing the procedural law that will govern the arbitration. And that requires an assessment to be done as to whether that is beneficial or not. So as a general point, I think it's a very welcome development. I think that choice being available to international investors investing through Indian vehicles is something which is required, and this will only facilitate more investment. As things improve and as there is more certainty about the different aspects of arbitration and the different steps in arbitration, whether it is pre-arbitration, during arbitration, post-arbitration, as things get clarified and there is maturity achieved, you will see less and less people wanting to go outside of India to arbitrate disputes. So that would be my view on that.
Thanks, Yogesh. And thanks, Vivek. And Yogesh, do chip in if you have a different view or you broadly agree with this, because I completely concur with, in fact, Vivek's point that while it is important to recognize that party autonomy, that exercise of that autonomy needs to be considered in addition, along with other factors like the cost associated with it, the governing law that you would like to choose, the very nature of the parties and the kind of disputes that may arise. So all of these factors needs to go into any decision making on what should be the seat of arbitration. But Yogesh, please do add in your thoughts as well, and then we can move into the next issue that we would like to discuss.
So Vivek has actually left very little thing for me to chip in. So he has broadly covered everything which is associated with having to choose seat outside India. And there are different considerations for the parties to choose seat outside India. And especially in a pre-2015 amendment era, there were reasons for party, the way Indian courts functioned, the way Indian arbitration functioned, and the way one of the Indian dominating parties were controlling the process of arbitration before 2015 amendment. So the foreign investors, the foreign companies, they were very averse to having a seat of arbitration being in India, considering it was a long drawn process, the arbitration disputes process itself. But of course, after 2015, the things were set into the right direction, and the recent judgments in the courts in India have further established the fact that you can have seat outside India. And when it comes to foreign investment in India, most of the companies who are having their Indian subsidiaries here, as Vivek also pointed out, that though there is an Indian subsidiary, but it is largely and essentially controlled by their foreign seated parent companies. So they would like to not only have a faster and better processes, time proven, and much more matured jurisdiction processes. So initially, I see that there was a little reluctance, and there were judgments which were not actually supporting the idea of having a jurisdiction outside India for the two Indian parties. But of late, especially after the PSL judgment which came in last year, so that issue is more or less settled, and it's a welcome move. It's a welcome move, and as Vivek also pointed out, that the seat of arbitration is not only it's only the venue, but it also give you a lot more avenues in terms of challenges and processes and all other kind of arbitration related processes. So it is very important, not only, I mean, the seat for the two foreign entities or two Indian entities having seat outside India, but even two Indian parties are also choosing their seat of arbitration for that purpose in a very, very carefully, in a very, very matured, or I would say that kind of arbitration friendly jurisdiction. There are some high courts which have the original jurisdiction. So people would like, even to Indian parties who are into the arbitration, they look for the seat where the court process are much more efficient and efficacious. Yeah.
Thanks, Yogesh there. So moving into the next element of party autonomy, I think we'll discuss various aspects of party autonomy. So just moving into the next aspect of party autonomy is the mechanism or the procedure for appointment of arbitrators. Now, particularly practitioners in India and the practitioners who have come across contracts involving government parties are used to seeing contracts or clauses which would say that in case any dispute arises under this contract, the right to appoint the arbitrator will, in some instances, it would say that a retired government employee would be the arbitrator, or it would say that the government retains the right to appoint the arbitrator. So the process of appointment, there wasn't a fair process, one may call it, or that the autonomy wasn't fully pronounced. Now, obviously, I think that there has been some clarity that has come up over the last few years where, now clauses which say that either one party will act as the arbitrator or one party will appoint the arbitrator, both are not enforceable contracts or clauses. Now, something, Yogesh, you would also have noticed is that there are many more ingenious ways of achieving the same outcome that you nowadays see. In fact, I recently came across a contract which provided for an arbitration clause, which basically said that party A would provide a list of 5 names of who could be potential arbitrators. Now, party B, who is the private party, will have to choose 3 out of the 5 and give their recommendations or suggestions to party A. And out of the 3 that party B, who is a party to the contract and party to the arbitration, therefore, has suggested or has recommended out of the 5 which was given by party A would appoint one of them as the arbitrator. So, when you see clauses like this, do you think that, the party autonomy that needs to be there when it comes to the process of appointment of arbitrators, is it really respected, or, we are time and again trying to find ways to move away from this cardinal principle and in fact find ways of retaining the right to appoint arbitrator with just one party?
So it's a very relevant question, especially from the perspective of the organization I belong to, I work for. So we have been dealing with these kind of clauses day in, day out. L&T being one of the prominent construction company, we do a lot of government work, and especially the domain I come from, I'm dealing with the railway business. So these kind of clauses are coming in and out in all the railway contracts, which is flowing from 1960s and 70s. And those, unfortunately, even after the amendment in 2015, and there are so many court pronouncements, such clauses continue to hold ground in most of the railway contracts. So we suffer these clauses because more or less, whatever you may say, these are most of time these government contracts are kind of a standard form contracts where the private party don't have much say in negotiating these clauses, and these are the clauses which is percolated down to these smaller government entities from the ministry level, and the whole process of getting these clauses amended during the time of tender and bid stage is a cumbersome process, and we get a standard reply saying that the clause remains as it is and no changes envisaged. So we have to take that risk and we have to live with those clauses. There have been instances where these clauses are there in a pre-2015 amendment clauses, and then there are even the newer contract I see continues to have such clauses. But the judgment of 2017 in Voestalpine case, in case of DMRC, tried to break this kind of mindset within the government contracts. And it was recommended in that judgment that you cannot just restrict your choice of number of arbitrator to the retired employees and retired ex-employees or particular domain expert, but your panel, even if you are giving a panel of some people to be the prospective arbitrator, it has to have people from all across various other domains and industry. Because when it comes to the contractual dispute, it is not only the people with the technical knowledge who are considered to be the good arbitrator, but you can have arbitrator, prospective arbitrator from other domain like economic, finance, engineering, legal, chartered accountants. So those kind of recommendations were made in judgment, but unfortunately even today uh, 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 the government department continue to follow such clauses, and they continue to give again the name of 5 clauses you rightly pointed out. So to overcome the effect of this judgment and the overcome the effect of the amendment in section 12 and 11 what is made in 2015, the government officers started to give you 5 names to choose from. And and they say that we are giving you choice, you can choose 3 names, and from those 3 we will appoint one on your behalf, and if you don't choose anybody, then also we will appoint somebody from your behalf. So those kind of instances are there. And they seek a lot of support from 2-3 judgment which happened in 2018-19, and there was some ambiguity on the operation of these clauses and those judgments. And very recently, last week itself, there's a judgment of Supreme Court. There's an order of Supreme Court in the matter of it is called JSW Steels versus Southwestern Railway, where such a practice has been denounced by Supreme Court, and it is referred to the earlier judgment of Tantia Construction, which the matter in the core judgment was sought to be referred to a larger bench and to have relooked into this. And we are just hoping as a private participant to the government construction process that sooner or later this larger bench will be constituted, and a very positive move will be made with the interference from the judiciary to have more clarity on such clauses. But however, despite all these clauses, in my personal experience, there have been many instances where the private parties have moved to the High Court seeking appointment of a neutral arbitrator under Section 11 petitions, and the courts have given the favorable decision appointing a neutral party. Since this 5-member limited panel was being provided from the other side, so the courts have taken a very positive and very encouraging view on these aspects. But still, there are some matter which has taken up in challenge in Supreme Court. The matter is pending. We are just hoping that going forward we will have more clarity and more better decisions from the court as far as parties autonomy's aspect of appointment of arbitrator is considered in a better manner.
Thanks, Yogesh. And in fact, as most of us know, there are now 2 references to larger bench, which is depending on the same issue. And that in itself just shows how the judiciary has also recognized that this is a problem. And and I am guessing that it's just a matter of time before we'll have further clarity on this aspect. Being conscious of time, just moving on to the another aspect of party autonomy again, which is on the point of choosing the court which can have exercise jurisdiction. Now, you see the exercise of jurisdiction of courts coming in both in the context of an Indian seated arbitration and a foreign seated arbitration. As I mentioned earlier, as far as an India seated arbitration is concerned, and just to explain on the position of law there, which is that as long as I confer the seat of the arbitration in, let's just take Delhi, for example, then courts in Delhi can have jurisdiction over that arbitration, and the supervisory jurisdiction over that arbitration will be with the courts in Delhi. So, while the parties to the contract may be based in Bombay and Calcutta, by just conferring seat on Delhi, you are automatically conferring jurisdiction on courts in Delhi as well. Now, that's one aspect which is that is in the context of domestic arbitration, because always Indian courts or the court of the seat will have supervisory jurisdiction. That's one aspect where there is a decision that needs to come in on the aspect of court, or which needs to retain the jurisdiction over the arbitration. Similarly, there's an element of court jurisdiction, even when you choose to seat your arbitration outside of India, because even if you choose to seat your arbitration outside of India, you still can give jurisdiction to Indian courts to grant interim reliefs or assist with taking evidence that is necessary for the arbitration. Now, I think, Vivek, we want to hear from you as somebody who has been involved in several such contracts, is that what are the considerations that goes into deciding upon where should be the seat be, so that you confer jurisdiction on a particular court, or should we at all have jurisdiction given to Indian courts when we are seating our arbitration, say in London? So as an in-house lawyer who's negotiating these contracts, what considerations do you keep in mind in deciding on a court which should have jurisdiction?
So, as you rightly pointed out, there are two important elements, and the broader point that I think you are making is that when you are drafting arbitration clauses, gone are the days when these can be midnight clauses. I think there is a lot of thought which needs to go into drafting these arbitration clauses, because there are consequences that are attached to what you ultimately agree. And it may not seem to be important at that point in time, but these are important considerations, and what you have just mentioned is one such consideration. So the seat of arbitration naturally means that you will be giving to the court of the place of the seat full jurisdiction in respect of procedural matters concerning arbitration, whether it is for appointment of arbitrators or whether it is in relation to the proceedings of arbitration, whether it is challenging the orders passed by the arbitrators during the course of arbitration or the final award. So one needs to be very sure and confident that you are choosing a place which is very well accustomed to efficient arbitration and is arbitration friendly. Now, there are some practical aspects that one needs to also take into consideration. It's all good to start an arbitration, but there may be instances where you need to preserve the assets involved, or you need to preserve the property, or you need to ensure that should a judgment be passed, there is sufficient financial strength with the other side to meet that award. And therefore, the important thing is how do you secure your interest? If you were to sort of leave it without mentioning that, then it would all be left to where the seat is. Of course, you can rely on the arbitrators to pass interim orders, but then you have to naturally come and enforce those interim orders where the defendant or the respondent is in respect of those interim orders. So it is important to consider whether you should preserve yourself in the arbitration clause itself an agreement that even though the seat is elsewhere, that doesn't prevent you from approaching the courts in the relevant jurisdiction for interim measures. And as an example of that, I think you now have recently in an amendment which was, I believe, which was passed after the Palco case, that in India, in the Arbitration and Conciliation Act, where if you have a foreign seated arbitration, you can approach the Indian courts for seeking interim reliefs, not only to preserve the assets, but also, for example, to produce witnesses and get them to attend and participate in the arbitration. So I think this is an important consideration. And from my point of view, I always like to keep that option available. It doesn't matter that it's mutual, but I think that option is only beneficial to have, even not just for yourself, but just more generally. So that's how I look at approaching this. Because the other consideration is that you first, going to emergency arbitrators is fine, but there is a little bit of uncertainty, and we'll come to that perhaps later in the discussion on the nuances of that. Sometimes for efficacy purposes, it is probably more advantageous to go straight to the court in the jurisdiction where the other side is. In other instances, it may be more efficacious to get an immediate order from the arbitrators and then come to the courts with something that can improve your case, or prima facie makes a case for an order, which the court can immediately then give you. So one has to play a little bit with that, but the important thing is to have the option to do so.
So Vivek, so I think the point that we are coming to is that it's important to retain this right when you enter into the contract. How you exercise that is a matter of how your dispute develops over the course of time, because you can't predict what your dispute is when you're drafting the contract. And while you draft the contract, you obviously don't expect that it will go into a dispute at all. Yes. So I think, so it's basically that it's important to exercise your choice or choice that the parties have, keeping in mind the commercial realities and the potential turn that the contract or the relationship with the parties can take. So I think it's very important to, therefore, as Vivek sort of mentioned, to keep these factors into consideration while you are drafting your arbitration clauses. And it's no longer midlight clauses, which is where you follow a general template. It is actually, I think, fairly heavily negotiated these days. It's fair to say that.
Now, and also, I can tell you that there are trends that I am seeing, that sometimes you end up negotiating whether there should be an emergency arbitrator or not. There are people who put forward exclusions of appointment. Now, what I'm trying to only get at is that there is more maturity coming as well, particularly when you're looking at institutional arbitration, where when you're choosing an institution, you must evaluate what are the rules, what do the rules offer you, and whether that is suitable or not, and whether you should take some other rules. Pardon?
Absolutely, in the sense that we've seen, in fact, Indian cases where similar situations, but one was governed by SIAG rules, one was governed by a Japanese set of rules, and the consequences were vastly different, because obviously what the rules provided really governed the issue. In fact,
earlier Sangyong matter.
Sorry?
Earlier Sangyong matter, where by reference article, SIAG rules were incorporated and the SIAG rule changed. And then nobody was conscious of that fact at the time of drafting a clause, because very casually there's a tendency, because as Vivek said, that and there was a tendency that this arbitration clause is one of the midnight clause or
The last
boilerplate
one
clause.
to be drafted when everything else is finalized. Let's just put something there. But I think, as both of you mentioned, that's really changing, because I have also seen in the last 4-5 years where arbitration clauses are heavily negotiated. In addition to the transactional lawyers, the disputes lawyers come in at the stage of negotiating the arbitration clause, because you're anticipating all what can go wrong and figuring out an
Absolutely.
arbitration clause.
So some senior business person is, I mean, somebody was mentioning that when there's a talk of two organizations getting into the contract in a relationship. So it was like, at the time of marriage, nobody discuss about the divorce. So dispute resolution is seen as a divorce proposition at a later point. So as an in-house counsel and as a been an arbitration practitioner for a long time, having spent over 18 years in the law firm also. So I see those clauses. I mean, when the contract come to me for review, then the dispute resolution is the first clause which catches my attention, because I need to see that in case of an unlikely event of a dispute happening at a later stage, then we should be clear about how it is going to be proceeded. And therefore our rules may or may not come, but at least there has to be a clarity as far as the processes of dispute resolution are concerned. There has to be utmost clarity on that, and you can't just deal with them casually, being a midnight or a boilerplate clauses. That's my thought.
Yeah, I think since both of you mentioned about emergency arbitration recently, and I've also seen that some of the Q&A that has come through also deals with emergency arbitration. It's also one of the most talked about things in the last couple of years now, actually, in the Indian context and also in other jurisdictions. In fact, Hong Kong and Singapore also had a lot of debate on emergency arbitration in the last 2 years. So it's globally a much discussed issue before various courts. So, to just touch upon this whole point about institutional emergency arbitration. Now, the first thing is obviously, as everyone's aware, it's something that does not come from the Arbitration Act as such. It's something that comes from the institutional rules. So the origin of emergency arbitration remains to be the institutional rules, and at least in the Indian context, it doesn't have a legislative sanction. Now, how relevant, I mean, I think there are a few aspects that I would like to discuss, but I think let me just start with the first aspect here, and, Yogesh, you could sort of deal with this point, which is that in a place like India, where I would probably think that 98% or more of the arbitrations still are ad hoc in nature, how relevant is this discourse of emergency arbitration? Because, all of us as practitioners do spend a lot of time talking about it. But how relevant is it in the current scheme when it's something which was only available within the institutional framework? So, to make it something which is more relevant, more accessible, is it important to, have a legislative backing for it? Or is it something an exception and, you always have a remedy for interim relief either before the court in a pre-arbitration stage and before the arbitral tribunal during the course of the arbitration? So is it something that, begs for a legislative change, or you would think that things as it stands is fine from a legislative perspective?
As far as emergency arbitration is concerned, so there is no mention of emergency arbitration as far as Indian legislation, which is the Arbitration and Conciliation Act as it stands today. There is nothing about emergency arbitration in this legislation, though there are sections which deals with the interim measures, interim relief to be provided, section 9 for the courts, and similar section which is amended in 2015 giving similar power to the arbitral tribunal also. But the whole process of constitution of arbitration tribunal and approaching the courts takes some time, and the whole purpose of emergency arbitration is more of a conservatory in nature. When you need immediate urgent relief, when the subject matter of the dispute need to be protected, or some interim order or some protective order is required by the affected parties. So as the things go in 246 Law Commission report, there was a recommendation to include about emergency arbitration in the amendment to the Arbitration Act, which unfortunately was did not find favor by the legislators, and it was not incorporated. However, with the famous Amazon future retail case, when the court was dealing with the emergency arbitration provision of the institutions which are governing the arbitration processes around the world and in India, the court has given recognition to the order passed by the emergency arbitrator appointed under the institutional framework. So we have institutions like ICC, SIAG, LCIA, International Arbitration Institution, which primarily deals with most of the time the international parties. But as far as Indian parties are concerned, there is not so much traction as on today to include the institutionalized arbitration in their arbitration clause. So that suffers. However, there have been a trend which is picked up by the Indian Arbitration Institution, like, for that matter, DIAC, which is Delhi International Arbitration Center under the aegis of Delhi High Court, which has their own rule, and they have whole section to their rules regarding emergency arbitration. And the emergency arbitration is getting momentum, and the institution like ICA and MCIA, Mumbai International Arbitration Center, they also include in their rules the provision for emergency arbitration. The good thing about the emergency arbitration rules today is that in Amazon case, the Supreme Court and the High Court has recognized the order passed by the emergency arbitrator, appointed under these rules. And the only negative thing which I see about the order passed by the emergency arbitrator is that this is open to review and challenge and reversal by the regular tribunal whenever it is constituted. So the emergency arbitrator as such become functus officio immediately after he passed the order. So the life cycle of the emergency arbitrator as such is very, for all practical purpose, emergency arbitrator is a full-blown arbitrator having all the powers which are there, including deciding on its own jurisdiction. But after the order is passed, there is no emergency arbitrator, and then the regular tribunal, which when it comes into the picture, they have all the powers to even reverse the decision. But the good thing is that as far as the enforcement of order passed by emergency arbitrator is concerned, the court has taken a positive view now, and the court have said that the order passed by the emergency arbitrator are the order which is akin to order passed by the court or the regular arbitral tribunal, and they are enforceable. So that is a good thing. And yes, process-wise, there is a need for emergency arbitrator and the order to be passed by the emergency arbitrator, because when the dispute comes, there is always likelihood of some subject matter of the dispute being, vitiated or damaged, and such kind of order is required. And though in the regular process, the emergency arbitration process is there in the institutional mechanism, which parties by choice and by consent can opt out of it. But in my experience, I have not seen any party, opting out of this emergency arbitration. And if going forward, if the recommendation is again maintained and again made towards inclusion of emergency arbitration in the legislation, it will be a welcome move. Though there is already a provision for interim relief in the legislation as it stands today, but including a particularly definition of emergency arbitration into the Arbitration Act would be a welcome move, and it will go a long way in further improving the and make the arbitration process a lot more efficient.
Thanks, Yogesh there. And, I think, as you mentioned, I mean, it's a quick remedy in the sense that, sometimes going to a court and also getting a Section 9 relief or an interim relief can take time. But emergency arbitrations often is the procedure itself is that within 48 hours, the arbitrator would be appointed, and the arbitrator has to complete the process in less than 2 weeks under most of the rules. So that that time element is definitely preserved. And, given the fact that there are, as you mentioned, a lot of people going into courts, it is something that can obviously be encouraged as a solution to parties to sort of obtain that much needed interim protective order at the time when it is in fact required. Just sort of moving, while I think we all agree that it's a good tool which is available. Vivek, just to come to you and then I'll come back to Yogesh also with some other aspects of it. But do you think that there is an appetite that you've seen amongst parties, globally, not just in India, to look at emergency arbitration as the most preferred way of getting, quick interim relief, or parties still look at courts as in certain circumstances as the one that need to be approached for immediate protective orders, or that recognition is something that is globally come through?
I think globally there is a recognition, because you find now the rules reflecting the change in this direction. So globally there is a recognition for a thing like this. In fact, in England, the courts don't go for interim relief unless the emergency arbitrator relief is not an efficacious remedy. So there is a tendency to try and promote more of that. But I think there are some practical aspects which obviously need to be considered in cross-border arbitration. In the sense that you can get the award of the emergency arbitrator, then you also have to go and enforce it. So then it comes down to the law of the place where you wish to go and enforce it, as to whether such an award will be recognized. Now, since you're talking of India, that is clearly an issue that still needs to be put to bed. In Singapore, they amended the law itself in 2012. In 2010, they introduced the provision, SIAC introduced the provision in 2010 for an emergency arbitrator. In 2012, the award of the emergency arbitrator was recognized as an award that could be enforced under the Arbitration Act, under the International Arbitration Act and the Arbitration Act. So therefore, I think it requires a statutory backing for it to be fully recognized, though I do understand that there are some judgments of the Bombay High Court where, even though the emergency arbitrator's award is not itself considered to be an award for the purpose of the Arbitration and Conciliation Act, but the court has given due weight to the award that was passed by the emergency arbitrator, and then passing the order on its own in terms of what was passed by the emergency. And now there are divergent views. There are some other high courts have taken a different view. So from a judicial pronouncement point of view, there needs to be some certainty around that. And until that happens, I think there will be a little bit of, people will be circumspect about using this. Having said that, it was, when I was reading SIAC statistics, they have said that in most cases, parties voluntarily respect the award of the emergency arbitrator. And there is actually an interesting question which one can explore, because under the SIAC rules, for example, there is a specific provision under the emergency arbitration clauses that the parties agree to be bound by the award of the emergency arbitrator. Now that, according to me, becomes a contractual obligation once you adopt the rules. So there is a risk there is a potential tool that could be used to sue a party for breach of contract and claim damages if they don't. Now that's to some extent that's an intellectual debate, but because in reality you want, but you want an interim relief, but that can be a bit of a stick that can be available to ensure that parties actually comply with the award without necessarily going to the court. So that's a bit of an aspect that needs to be bottomed out as far as India is concerned in terms of enforcing the emergency arbitrators awards.
Thanks. And in fact, while there is, emergency arbitral awards are recognized under as an order of an arbitral tribunal in the Indian context. What kind of recognition can come in for an emergency arbitration award in a foreign seated arbitration is still an open question and needs to be settled. And in fact, while courts have been reading the Arbitration Act, in fact, to give full intent to the legislation and also to encourage arbitration, hopefully there should be a solution that will come through soon for this issue. But typically, as Vivek rightly mentioned, what is happening is that on the strength of the emergency arbitration award, there's a fresh proceeding which is initiated in India to get similar orders, which can then which can then attract the consequences of non-compliance. So I think that's practically how we are all getting around this issue. Yeah. Just one last point on emergency arbitration, which is that unlike going to court for interim relief where the court fees are nominal, there is a fee which is obviously attached to going to emergency arbitration. Do you think that will be a consideration that would work, or that fee is something which parties over the course of time would learn to be a part of the cost of the arbitration and move ahead with it?
I personally don't think that's a deterrent, because you will always weigh the cost. Either you go to India and do it, or you do it through an emergency.
You will always hit the cost.
You will have
Yogesh, you agree with the same, or you have a different view there?
Yeah, I think that is not a deterrent at all, because considering the stakes which are involved in the matter requiring the emergency relief from the emergency arbitration, I think the cost would not be a deterrent at all. In fact, it would further the cost. I think the kind of relief the affected party would be expecting, that cost will be very minuscule part of the total quantum, engaged, involved in this whole matter.
So, I'm absolutely conscious of the time. We are maybe 25 minutes away and we've got a fair number of questions. So just before we wind up, and we've been on the first bucket as I started with, which is a party autonomy all this while. So just to touch upon the second bucket, actually the second bucket or the third bucket, we can call it either ways, which is one of enforcement of basically challenges to the award and enforcement of arbitral award. One of the practices that we've all seen over the years was that the minute there is an arbitral award, the judgment debtor would immediately file a challenge against the award, and then you have 3 levels of appeal process which would be there, which would take its own time, the reality of it. And during this entire period, you could not enforce the arbitral award, and basically the decree holder or the award holder was sitting with a paper award in that sense for the entirety of the time. Now, obviously, in the last 5 to 6 years, there has been a significant amount of effort that has been taken by both the legislature and the judiciary to cut down on or modulate the grounds on which there can be challenges to the award, keeping in mind that you also need to have that ability, but that ability should be sparingly used. There's enough jurisprudence which has been created. Second thing is that there is a very conscious effort from most courts, and out of experience, we can all attest to the fact that these matters are heard much more expeditiously than what it used to be in the past. And in fact, when you have SLPs going from the Supreme Court against challenges to the arbitral awards or challenges to enforcement of foreign awards, in both these instances, they're fairly clear that we are not interfering unless until there's something extremely egregious which is being pointed out. So I think that aspect is fairly getting settled, and it's a case-to-case determination which is happening, both timeline as well as the grounds. But what I have always found to be a very good development, which came hand in hand with obviously limiting the grounds of challenge and also increasing the expediency of deciding these setting aside challenge petitions, is the fact that there is no automatic stay to the enforcement of an arbitral award. So in fact, the party who has got an award can start with the enforcement process in parallel unless until there is a specific stay which was granted by the court. And also the stay against enforcement is not something which is given for the asking. It is something which comes with conditions. And we've all seen instances where even the entirety of the award has been asked to be deposited. So, I mean, this is more a question for Yogesh, and coming from a place where you have many of these arbitral awards, including state utilities and other parties. How is this development, which is that you can enforce the award until there's a stay, and even if there's a stay, there's a deposit which you can withdraw, etc., helped you and similarly placed organizations in your business, which is that does it add to your working capital? Does it enable you to really enjoy the fruits of the arbitral award once you have fought and won the arbitration?
Very interesting question, I would say. So there have been many instances where we have got favorable awards from the tribunal, and so the award comes, everybody is upbeat about the whole thing, that after a long drawn process we have been able to secure an award in our favor, and this money will come in, and the justice has been done finally. But what happens is that, number one, so there's a timelines now for making a challenge to the award in the court. So that first we have to wait for that 90 days
90
plus
days, yes.
30 days period to seek enforcement of that award. And all these, if we are up against the government institutions, so they have another tool in their hand, which is the recommendation by Niti Aayog, which has been incorporated into a lot of government organizations' standard operating process, which they call, there's a CCA recommendation which came in 2016 originally, which was further amended in 2019, which allows them to challenge the award while admitting payment about 75% of the payout against the submission of a bank guarantee. But it is not that easy as it sounds, because this 75% amount which the contractor is entitled to, this amount is not going directly to the contractor or the consortium, but it is going into the escrow account, which again is largely controlled by the mechanism where the employer himself is controlling the outflow from that account. So that's the policy which is made out by most of the PSUs. So this amount, so they always, give you a kind of this carrot that will pay you 75%. So first we have to wait for 90 days plus maybe another 30 days. So
yeah, so 120 days wait period is there clearly, but
yeah.
As against 15 years, I would say that 120 days is
yes.
nothing.
So that you have to wait, and thereafter they also make out a case, they being a government department. So they also make out a case for condemnation of delay after 90 days. So very easily the courts have been little lenient in granting that 30 days condonation to them. That's been my experience. And on a larger aspect, when you're dealing with the governments and PSUs, the tendency with with us and maybe other businesses, because we do a lot of work with the government sector, the tendency is not to go for the enforcement process because of the relationships and the multiple level relationships and the contract work being executed for these government agencies. So the enforcement is not there. Had it been the arbitration award amongst two private parties, then the courts are very clear that if somebody has to challenge the award, then the courts are very happy to pass an order where the 100% deposit or 50% deposit is made out. But unfortunately for the government sector, when the senior government legal counsels are standing and making a plea that we being the government, and there is no point that government is not be able to able to honor the award at a later stage. So they have been able to get the order where 25 are, deposit of 50% or 25% is being made. And those but the only good thing is that the courts are also willing to pass an order where 100% of the pre-deposit amount can be secured against the bank guarantee, subject to the final order of the court. And another good thing which I see is the courts are moving much more faster now in deciding a 34. But unfortunately, we have a live case which is going on, which the whole of the construction industry has been watching very closely, which is the DMRC and the Reliance Airport Express Metro matter, where the award was passed somewhere in 2000. The arbitration started in 2012. The arbitration award came after 3 years, and it has gone into the multiple level of challenges, and including it was rejected by Supreme Court. Supreme Court took a very arbitration friendly view in the challenge in SLP, and they rejected it. And I'm told that even the enforcement proceedings are pending in Delhi High Court, but despite that, the award holder has not been able to get the award amount as of now. The challenge is going on, and even after the Supreme Court rejected it, it's been almost a year, and the private sector participant is still struggling to get an award. The kind of argument which is being made, the whole construction industry is watching that matter, I believe, very closely, to say that we are the government and we are the solvent party. And but DMRC has taken a view that we don't have any money of our own, and all the money which is lying in our bank account belongs to different projects, and we don't have money to pay, and therefore we should be given a right to negotiate with the actual lenders. So those kind of arguments are coming in, but yes, the award remains the award on paper only. So not
while
much of
there is a much acclaimed and applauded development which is there, unfortunately on ground it is not translating into real money in the hands of the winner in a whole arbitration. So so I think with this, while we did plan to discuss many other issues, I think we are running short of time. So I would just straight away jump into some of the questions that we have received. So just starting with it. So just both Yogesh and Vivek, please feel free to jump in on this. One of the questions is, how is technology changing the way in which disputes are handled?
Vivek.
Yeah, let me take a stab at it. So I have, as I'm sure all of you have, experienced the pre-pandemic and the post or during pandemic arbitrations. So I have done an arbitration during the pandemic, and it was resolved much quicker than the pre-pandemic arbitration. Now, I don't have much to complain because it went in my favor, but I think there are some aspects of technology which work brilliantly. And there are some aspects where I still feel that technology can't replace the physical presence. And these are all driven by practical considerations. There is no sort of personal or an emotional or such kind of consideration that you have to be present because you can't make an impact before the arbitrators. That's really not the point. So my take on this is that all this is a very welcome development, because what it has brought to fore is that firstly, you don't need bundles and bundles of papers to conduct arbitrations. And I think all parties involved have had to get a bit tech savvy in terms of dealing with arbitration without necessarily having big bundles of paper. Secondly, it has also brought to fore and confirmed that you can do a lot without having physical hearings. So all procedural hearings can happen without the need to have a physical hearing, and that can significantly expedite the process of arbitration. The couple of areas where, and you can also perhaps deal with interim measures that you bring to arbitrators, and those interim reliefs or interim procedural matters can be resolved by remote participation. There are, however, a couple of practical matters. So what I have experienced, for example, is that in a case where you have physical witnesses involved, I think there is tendency to try and not follow the rules in relation to witnesses being required to be alone and left to themselves. And there is some kind of prompting that goes on in the background, which is obviously not fair and correct. The larger issue is around the inability to instruct your counsel. And that for me was very frustrating, because I was not able to be present myself. My counsel, my briefing counsel, was not able to be present with the senior counsel, and we were just desperately trying to communicate over WhatsApp, and the poor senior counsel was getting thousands of WhatsApp messages. He didn't know where to look and what to do, and so he chose to practically ignore it, because it was just confounding for him that how does he deal with it. So I personally think that there are significant advantages, but from a practical perspective, it is difficult to replicate, to substitute physical presence in certain matters relating to arbitration. It certainly has expedited the conclusion. It has certainly made it more efficient. It has certainly made it more environmentally friendly. There are no questions about that. But it can't go the full way as of now, as far as I can see it.
Yeah, I think evidence recording is one aspect where physical hearings is something which is still. It also depends on the nature of the witnesses and the kind of evidence which is being led. I mean, personally, I've had expert witnesses being cross-examined through a video conference, which went absolutely fine. But I think it would not be the same if you are dealing with a fact witness.
Yeah, correct.
On certain facts. So I think it's something which at the end of the day, it also becomes that technology is a useful tool which is available with you. You need to know how best to use it to the circumstances that are in hand for you. But obviously, expediency in the form of hearings is one aspect. Just one point that I thought I will add in before moving on to Yogesh on this point is that technology has really enabled the manner in which we do discovery in arbitrations. Like 15 years ago, personally, I've sat through lakhs of pages as part of a discovery exercise to try and figure out what documents to be disclosed and what documents need not be disclosed. These days, you have all kinds of tools which is available to lawyers, which is available with other consultants who helps you search through certain keywords. You don't have to physically spend 1,000 man hours to do a discovery exercise. It's something which gets done in 1/10 of the time. So really technology has helped in aspects like that. Similarly, live transcription, another aspect of technology use, which is really helped all of us in conducting the arbitration. So I think while a lot of our focus do remain on expediency and virtual hearings, these other aspects, and this has been development over the course of years, which has also really helped the process. But I think the fundamental point is that we need to learn to pick what is the best suited for us and the specific arbitration that you're doing, and then find the right balance. Yogesh, do add in if there are further thoughts from your end on this aspect.
Yeah, on technology part, I would say, I mean, though I am a little old school person when it comes to documents and papers and everything. So but technology, I would say the pandemic has come in as a blessing in disguise as far as arbitration processes are concerned, because the things have started to move much more faster, though there were some initial teething problems were there. And with especially when you have a very senior retired judges and the senior engineers and bureaucrats who were not so familiar with the technology, so we had a little bit problem. We had matters which were ripe for the cross examination, or the pleadings were complete, and the main process of arbitration was yet to start. But it took us some time to get them on board, but eventually the things became much faster, and they were also very comfortable doing it with the comfort of sitting at their home and everything. As Vivek pointed out, the problem with briefing a counsel uh, remotely, and the other one is about the witnesses. So after doing many matters during the last 2-3 years on the arbitration virtually, so my takeaway is that at least the arbitrators are very happy doing it on a virtual platform, because they are sitting in their offices, and they can jump in from one arbitration to other arbitration, and they have necessary assistance available to them. So they are much more relaxed, and they are not, if not relaxed, at least they are not so much exhausted. So the travel
And
time
they
is
can
very,
do,
very cut.
and it's also increases the number of arbitrations that they can also
they
attend
they
to
are
in
able
a
to concentrate.
virtually.
Yes, so it is time efficient, it is cost effective. And there was little problem only about sharing of documentation and all that. And as far as the cross examination concerned, that is something what we have tried and which worked really well. So what we have done in during the cross examination is that one person, when we are cross examination a fact witness from the other side, and since we have a people or the lawyer available in that city or that jurisdiction available, so there was one person who was sitting along with the witness in that room. And similarly, when our witness was being cross-examined, the other side sent out one of their officers sitting in the same room where our witness was sitting. And so that way, even the cross-examination also went off pretty well. As far as if you have a stable, good system in place. So I think this technology bit has really helped the arbitration process really well. And as far as briefing council is concerned, so we decided, I mean, the briefing council and the all side, we decided to sit at one place and do it collectively from one screen. So that really helped. So it worked well for us. So I would say that technology bit is helped the lawyers also that way, and everyone is much more comfortable that way. And I got to hear it from our external counsels that they are very happy doing it remotely. Though the physical hearing has its own charm and the benefits, but largely I would say the tilt is towards the technology and the online hearings.
Uh, while we have a fair number of questions, I am actually picking some of the questions, and we may have to skip the other, and we will coordinate with the participants directly and come back to you with the answers. But just I will try and take
just to let you know, you just feel free to take a a couple more. Please go ahead.
So that's what I'm trying to do, maybe one or two to the extent possible. The next, and it's an interesting question, and I'll open it to the panel first and then probably add in some of my thoughts as well, which is that with the rise of dispute funding, how is this likely to shape the future of arbitration scene in India? Vivek, would you like to chip in with your thoughts?
Well, I'll let Yogesh go first.
I have a little
India-focused question.
Yes, so dispute funding, it is still in the nascent stage. I have my reservation against the dispute funding process itself, because what is being funded is the awards, not the claims. So that's my understanding of the dispute funding as of now. So the funder are coming in with a lot of due diligence being done and everything. And what is being my understanding and my collection is that as of now, the people are interested in the awards, not the dispute process.
Vivek, any thoughts?
Well, I have heard debates now being held on dispute funding in its traditional sense of funding arbitrations, not the awards, as Yogesh mentioned, and that is something which is a subject that is picking up. I'm a little unsure about the need for it, because I look at arbitrations more from a commercial point of view, and commercial organizations should not need to obtain funding. If the idea is that individuals should resort more to arbitrations and they need funding to go to arbitration, that perhaps is not necessary. And I fear slightly in terms of that the culture that may be promoted with that. I don't think it will stop necessarily at that level. It may start percolating in different directions. But the debate is on. I think the subject cannot be avoided. I suspect. And
there are a lot of interested parties who are into funding. And in fact, just to step in with some thoughts here,
please.
There is, while India, as both Vivek and Yogesh mentioned, it's more at the nascent stages. And it is true that in an Indian context, the funding is more in the context of a post-award scenario where there is an award which is already there, and it's the challenge to the awards and the enforcement process where you see a lot of litigation funding that is coming in. But in several other jurisdictions, you do have the entire dispute being funded by third-party funders. Now, when you have third-party funders coming in, they obviously, as Yogesh also mentioned, do a fair bit of diligence before putting their money in. What the third-party funding to a litigation or an arbitration would do is that they will come in, they will fund the entire process, have a say in appointment of the lawyers, have a say in the conduct of the entire arbitration. And there would be an agreement between the funder and the party to the arbitration that if you win the arbitration, 50%, 60%, 20%, whatever it is, of the awarded sum would go to the litigation funder. So they're basically making, basically investing in a risky proposition and gaining making a gain out of it if there is eventually an award in favor of the party. And what the party is also doing is hedging their risk, because you're not investing a lot more money into running the litigation when you have somebody else who's willing to put that money there. So yes, in that sense, this is a trend which is definitely growing. It is picked up really in several jurisdictions. In India, it's mostly in the post-award stage currently. It hasn't really percolated into the stage of disputes. Now, how would it affect the manner in which the arbitrations are done? As I mentioned, you will have not just a party to the arbitration, but also a funder who is sitting, who is looking into the strategy of the arbitrations, who's looking into the point of appointment of counsels, looking into what pleadings to be filed, what decisions needs to be taken. So it is, yes, bringing in that additional level of scrutiny to the process, additional level of commitment to the process. And also you have a entity who is a sophisticated litigator in that sense, because the third party funders are ultimately sophisticated professional, professional litigating parties. That's ultimately when they take up this role, who will also bring in their experience into the whole running of the matter and the strategy decisions which could be taken. But as a flip side to that, which is, keeping apart the whole legal issue of whether what is being assigned is shampoti or whether there's a assignment of a right to sue, all of those issues apart, because those are also live issues where there are some clarity which has come through in parts, but those issues still stay live in part, at least in the Indian context. So, so those legal issues are definitely there, in addition to the issues of whether there's a shambutious transaction. There's also the point of, the manner in which the arbitration will get conducted, which will get impacted with this issue. I think we will just take maybe 2-3 minutes, and I'll ask one more question, which I will leave it to both Vivek and Yogesh, because that's not a question for me. It's a question for both of you, which is that what do in-house counsel expect from law firms during the arbitration process, and what does a good representation look like? So it's clearly a question which is not for me to answer, and I will leave it to both of you to come in with your thoughts.
Yogesh, please go first.
Oh, so for me, it's a difficult proposition in the sense that I mean, larger part of my career has been a counsel myself. So I would, my first expectation from my counsel is to put in as much effort as I used to do, and I had been doing that. So the expectation is that the counsel has to own the matter. So basically, it cannot be the superficial ready-made advisory, but the counsel has to align with the requirement of the business, the requirement of the client, and they have to own the matter, and they have to be very passionate about the whole approach and whole the thought process of the client. Because when the client is putting in so many effort, there's a business decision which are involved. And as an in-house counsel, what I've learned is that sometimes some decision have to be taken in the interest of the business. So in business, everything cannot be in black and white. So it cannot be purely legalistic approach. There are certain calculated risks which the business has to take to run the business. So the law firms and the counsel have to understand that requirement, and they have to align themselves and propose a viable win-win situation to deal with the matter. So that's how you have to look into the situation from the business perspective also. It cannot be the pure legalistic approach.
Thanks, Yogesh. And I would concur completely with that. And I think, I personally think that the external counsels have a significant role to play, and bring a lot to the table. What I look to them for is obviously, they get to handle the matter. They need to do what needs to be done to present it properly. But what I look to them for is their deep expertise in terms of strategizing for the arbitration. Arbitration is not, in my opinion, and that's how I have viewed it always in my role now, it's not about presenting a case. It's about what you want to present and how you want to present. What should you focus on? You need to look 2 steps ahead on what can come. And that comes with experience. That comes with the ability to anticipate, and comes with the knowledge that you have. So to me, external counsels who can bring that to the table bring significant value, in my opinion. And that's what I have been I look to them, look up to them to bring to arbitration, and rely on them quite significantly for that.
Thanks, Vivek, Yogesh. We have overshot the time by now. Thank you for your valuable inputs and being part of this discussion.
Thank you very much for having me and for inviting me to this panel. It's been very interesting talking to all of you, and I hope that it's been interesting for the listeners too.
Absolutely. Thank you very much. That was, I think, remarkably interesting, very comprehensive, very useful. Huge thank you to Trilegal, to Tini, of course, to Mr. Gupta, Mr. Gambhir, to our audience today. If you have any further questions, I do encourage you to contact Trilegal and specifically Tini, of course, and hope to see you at another webinar shortly. Goodbye, everyone.